Yes, that's the family case. It's an independent case. He was able to find the provision job. We are facing it.
The whose office? The Sam's office. So what's the plan now?
They want to file a motion.
Processing aside of that judgment.
Judgment has been reserved. Then file their processes.
Okay.
It's not fair.
I don't have processes on this. Good morning, sir. How are you? Fine, thank you. Good morning,
Good morning, sir.
Mr. Maxwell. Good morning.
Welcome to Pulse Media Services. The prescribed leader of indigenous people of Biafra, Nnamdi Kanu, as we all know, has been sentenced to life imprisonment by Justice Omotosho sometimes last year, and efforts to get him out of the Sokoto prison to a prison closer to Abuja or considered to be safer has been met brick wall as the judge that gave the ruling for his sentencing in the first place refused to consider the motion to get him out of that particular prison facility to another. But of recent, the counsels to the IPOB leader filed an appeal to get him out of that prison, and they want in that appeal to quash the order made by Justice Omotosho, as well as Justice James Omotosho, delivered that ruling that sentenced Nnamdi Kanu to life imprisonment. But of course, the convicted leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has lost a 22 ground of appeal to quash November 20th, 2025 judgment of the Federal High Court in Abuja, which sentenced him to life imprisonment. Now, Kanu, who was convicted on a 7-count terrorism charge, the federal government preferred against him. In the notice of appeal he personally signed, insisted that the trial judge, James Omotosho, held the law and occasioned a grave miscarriage of justice against him. Now, in his first ground of appeal, Kanu maintained that the trial judge held in law by failing to resolve the procedural and competence consequences of the foundational disruption of the original trial process in September 2017, Operation Python Dance 2, thereby occasioning a miscarriage of justice. Now, given the particulars of the error, Kanu told the appellate court that in September 2017, his residence at Afara Uku was invaded during Operation Python Dance 2 by Nigerian state agents. Now, the said operation resulted in deaths and destruction and triggered disruption of the earlier proceedings. The appellant's case thereafter proceeded in a manner that required the trial court to first determine the legal effect of that foundational disruption on competence. The trial court proceeded to take evidence and deliver judgment without first resolving the foundational competence implications arising from the said state action. The judgment of conviction was delivered on 20th November 2025, notwithstanding the unresolved foundational competence issued. He added, now, Kanu told the appellant court that Justice Omotosho equally held the law by failing, refusing, or neglecting to hear and determine the appellant's pending preliminary objection, challenging the competence of the proceedings before proceeding to trial and judgment. He contended that his objection, which was supported by affidavit evidence, challenged the competence of the proceedings on threshold jurisdictional grounds. The learned trial judge did not hear or determine the objection. The court proceeded with evidence and delivered judgment on 20th November 2025 while the objection remained pending and undermined. In one of the grounds, Kanu argued that the trial judge proceeded to judgment and convicted him when his pending bail application remained undetermined, thereby affecting the fairness of the process. Besides, the embattled High Court leader contended that the trial judge had in law by imposing sentence without taking the appellant's allocution and by imposing excessive and or unlawful sentences without considering relevant mitigation factors. According to him, upon conviction, the appellant was not afforded the opportunity to address the court in mitigation allocutive. Sentence was imposed without allocutive. The court did not consider relevant mitigation or sentencing factors. Now, the issue here is that on the issue of allocutive, to the best of my knowledge, we saw some men that the judge appointed to help Nnamdi Kanu with allocutives, and then they made the allocutives in front of the judge, and is pleading for mercy for the trial judge to reconsider his sentencing. And then we could see that the judge now gave the sentencing, reduced the sentence from death penalty to life imprisonment. That was what was really what we saw on the TV then. But of course, we don't know why Nnamdi Kanu has to bring that back again. Of course, that allocution happened when he was not around, so we don't know the viability of this. But we keep you posted. That is how we believe that the court will do the right thing. Justice will prevail in this matter, considering that the fact that you have not one judge, not two judges, I think about 3 judges that will be dissecting that will look into this judgment made by Justice Omotosho on November 20th, 2025. Don't forget to like, share, subscribe to this channel. I'll see you in another video.